With that, I'll call the first case on this morning's docket. That is case number 102570, Elizabeth Shirley as mother and next friend for Zeus Graham, appellant, v. Imogene Glass, Baxter Springs Gun and Pawn Shop, and Joe and Patsy George, appellees.
May it please the Court, John Lowy for appellant Elizabeth Shirley. Mr. Chief Justice, I'd ask permission for 6 minutes for rebuttal.
6 minutes is granted.
Thank you, Your Honor. The Court of Appeals has held, and it's not appealed, so it's the law of this case, that there were material issues of fact that the appellees, who I'll call the Georges, illegally sold the gun used to shoot Zeus Graham to a known felon, that they also violated federal law. They also violated federal law in regards to falsely filling out the federal forms. The court held that there could be an adverse inference taken from their failure to produce videotape of the sale, which they claimed had been eaten by the videotape machine on that day. The court also held that there is no intervening cause as a matter of law that would supersede liability. And the court held that the facts support the existence of a special duty on the part of the Georges to protect Zeus or others from injury or harm, and therefore the negligent entrustment count could get to the jury. However, there are two errors in our view that the Court of Appeals made, and that was in failing to allow the negligence per se and simple negligence counts to get to a jury. To begin, on negligence per se, there's no question that a jury could find that the Georges violated the law, and the harm that was caused as a result was precisely the sort of harm that those laws were intended to prevent. In this case, the shooting of an 8-year-old boy by a known felon.
Explain to me the application of the statute that you're referring to and how it plays into the facts of this case. I'm having trouble seeing how that fits.
The Georges, as licensed gun dealers, Your Honor, were not allowed under the law to sell a gun to a felon. They were also not allowed to engage in a straw purchase. That is,
they didn't sell the gun to a felon, did they?
They effectively did. They were also not allowed to engage in a straw purchase. That is, they were required to sell the gun to the actual purchaser. And as the Court of Appeals held, and that is the law of the case, not appealed, that the facts would support finding that the Georges knew that Russell Graham, the felon, was the actual purchaser. And in fact, he had called up and said he was going to buy the gun. He selected the gun. He paid for the gun. But he was going to buy the gun, except when he said to the Georges, "I am a felon." In which case, their response was to turn to the woman who was with him and say, "Have you been a good girl?" And then they began initiating a background check. That is a classic straw purchase, in that they were going to supply the gun to the felon through a sale to the woman with the clean record who did the paperwork. That was illegal. And the Court of Appeals held that the Georges could be found to have aided and abetted in the filling out of false information on the 4473. Again, not appealed.
An exception to the straw purchase prohibition is if it's a gift. If you're purchasing as a gift for another, that's permissible.
If it's a felon cannot buy a gun to give as a gift. So it was illegal to sell to Russell Graham either directly or through a convoluted straw purchase, either way, regardless of what Russell Graham was going to do with it or what the Georges thought Russell Graham was going to do with it. It is no defense for a gun dealer to say, I sold a gun to a known felon because I thought he was going to do nice things with it. That is absolutely no defense. It would not be a defense in a criminal case.
I understood the federal law explanation in your brief, but I frankly got a little lost on the state law protections. What are the state laws that were violated by the transaction as you see it?
Your Honor, in candor, we will focus entirely on the federal law. It's a stronger case on the federal law, and Kansas law is more limited, and we will rely on the federal violations.
That explains why I didn't see it. Okay.
We pushed it harder on the trial court level than on the Court of Appeals.
So state law is off the table.
For the negligence per se action, yes. Okay. And Your Honor, in this case, what we have is clear congressional intent to allow negligence per se liability in cases just like this. In the Protection of Lawful Commerce and Arms Act, enacted by the Congress in 2005, Congress specifically approved of negligence per se actions for violations of gun laws by gun dealers. So you have a violation of law, you've got the harm that the cause that the law was intended to prevent, you have a law that was an obligation of the Georgias to obey, you have congressional sanction, legislative sanction of this sort of cause of action, yet you have no negligence per se action because this law, according to the Court of Appeals, did not protect a special class. Now,
right, once you've established the violation of the federal statute here, how does this operate? Explain to me what occurs once you've established that the statute was violated in this transaction. Does that create a strict liability? What does it do?
Well, if negligence per se applies, as we say it should, if the Court of Appeals decision is reversed on that, then, and the way it applies in every other state other than Kansas, is that you have a negligence action, yet the standard of care is the minimal standard of care, which is the federal law. And so at least it's the minimal standard. So that means that there's jury instruction that if you find that the defendants violated this federal law, then they are negligent. It's not strict liability because you still have to prove causation, but you've proven a breach of a duty, which makes perfect sense. They have the duty. Georgians have the duty to obey federal law. It's the minimal duty. They have a greater duty under the civil justice standard, not a lesser duty. Yet under the Court of Appeals decision, they actually have a lesser duty, and it actually allows jurors in a civil case to effectively nullify criminal law, which they would not be allowed to do in a criminal case.
It seems to me that you get a little circular when relying on the federal law and then trying to look at least the modern negligence per se law or the most recent negligence per se law here in Kansas, because we talk about the expression of legislative intent that there be liability. And as I understand your argument, you're sort of saying that the expression of federal legislative intent for liability is the reference to negligence per se actions. But then if you circle back around to how Kansas looks at negligence per se, we're looking for an affirmative legislative intent of liability, and traditionally we look at something that gives us some indication that within the law that they're supposed to be liable. And I think you're missing that link, aren't you?
I think that's a fair statement that we are trying to. Our major argument is that, as Judge Malone stated, Kansas should go back to the negligence per se standard that every other state has, and that Kansas applied certainly up through the Nolan case, and has actually intermittently referenced back in the Bland case, which is that if you violate a law, that can be the standard in negligence action. You can have a negligence per se action unless the legislature expressed an intent not to have civil liability. So you don't need an affirmative expression of civil liability. The assumption or presumption is that there's civil liability unless the legislature says otherwise. That was the law in Kansas, certainly up through Nolan. And it's it's appeared actually since then. And the problem you have in limiting negligence, one of the problems you have in limiting negligence per se liability, for one, as Judge Malone said, and these are his words, is that there's no rational reason to limit the law in this way. Why do you have a standard that applies if it's a law that's intended to protect the general public, you don't use it as a standard if the law is intending to protect the general public, but you do use it as a standard if it's protecting a limited class. And you have also a very difficult problem in applying that standard. So you have, in cases like in Schlobaum, you have the court saying that there is a special class of people who enter and exit through doorways. And therefore, that code relating to doorways protected a special class of people. You have the O'Neill case, the Court of Appeals case, where the court said there is not a special class of people who walk up and down staircases. So there's not negligence per se in that case. It looks to most people, I think, that those are very similar sorts of codes, yet you have two different decisions. And in fact, we would argue the class of people protected by the gun laws violated here is every bit as special and limited as the class of people entering and exiting doorways.
But that's your backup argument.
That's
counsel.
the backup. I think the first one is following Judge Malone's advice and revisiting the Noland rule. And I see my time is up.
Well, we'll go on a little further
Okay.
as long as we have questions. If we accept your argument on the negligence per se, your primary argument, do we end up then reversing, for example, the Ling decision about selling alcohol to minors and bartenders being liable for selling to minors illegally?
No, I
Why not?
do not think so, because in Bland v. Scott and Ling, the same issue, dram shop liability, there was legislative intent not to have civil liability. And the court, in fact, went into that in great detail. It went into the fact that Kansas had dram shop liability, repealed it, considered it in other sessions, didn't pass it, and actually concluded there was clearly an intent not to reinstitute dram shop liability. So you would not reverse those cases. And legislatures certainly could make that point in other legislation. I see I've not even touched on the negligence argument, but which I will address on rebuttal then.
Do we have any more questions? Thank you, counsel.
Thank you, Your Honor.
May it please the court, Scott Nervous of Folston Seatgun on behalf of the defendants, Baxter Springs Gun and Pawn Shop, and Joe and Patsy George. And if I may apologize in advance, I've had a terrible flu, and the weather this morning may have me coughing a bit, and I want to apologize in advance for that. As I understand my opposing counsel's argument this morning, it is that there should be a sea change in the laws of this state on negligence per se, and that our legislature should now be notified that any time you pass a statute, ladies and gentlemen of the legislature, you better be sure and say you did not intend by passing this statute to ease the burden of any plaintiff in any civil liability action in which there might be some connection between the violation of the statute and somebody getting injured. That's essentially what he's asking you to do, to slam into reverse what Kansas law historically has been on negligence per se. And not just a few cases,
that
but a
presumes
lot.
that negligence per se is a whole different animal altogether. It seems to me that in this instance, all we're really saying is that under a regular negligence action, the gun shop owner has certain duties. And when it comes to the sale of firearms, that duty has been prescribed by the law as to what they're supposed to do and what they're prohibited from doing. It's just merely an establishment of what their duty is. And we could find, as a matter of common law, that they had a duty of care not to sell a firearm to someone that's going to kill another with it, couldn't we? You understand what I'm saying?
I don't quite understand your question.
As a regular negligence action, you set the duty of the actor, correct? And all we're saying is that
The first thing you prove in a negligence action is duty. Duty, breach,
yes,
causation.
and that's definitely what negligence per se relates to, is duty and breach of duty. And it eases the plaintiff's burden of proving duty and breach of duty. So, for example, in the Lewis case from New York, that Pemberton relies upon, among other cases from other states in which it was decided, no, there's no basis for negligence per se claim here under the federal firearms statute. What the sales clerk failed to do wrong, what the sales clerk negligently did, is he didn't quite write down the gun buyer's driver's license number correctly. That was the negligence. The person was allowed to buy a gun. The person used the gun to hurt someone. And
but how,
the negligence per se, pardon me, Your Honor.
What is the logic of saying that we do not have a duty to follow the law? That a gun dealer doesn't have the duty to follow a law? That I, as a citizen in some other way, where there is a law that says this is what society expects, why doesn't that impose upon me a duty?
Your Honor, that is not what I'm arguing, and I want to be real clear about that.
Okay, because I thought your answer to Justice Johnson's question suggested that you were saying something along that lines.
I think the only way to approach and answer your question and Justice Johnson's question is basically to go back to a real basic premise. And that is, any time a legislature or a city council passes an enactment, some kind of legislative enactment of some sort, the expectation is that that law is going to be enforced. And it's going to be enforced by someone, whether it's law enforcement, it's the Kansas Department of Health and Environment, it's the Kansas Corporation Commission, it's somebody. And that is the expectation. But is there an expectation that every single time the legislature or Congress or whomever passes a law, that the result of that law is going to be to ease the burden of some plaintiff in some civil liability action?
It is in 43 states and under federal law. Isn't that recognizes negligence per se? Well, Kansas is in the minority in that.
Yeah, I recognize that, and I acknowledge that, although I want to point out here that the Court of Appeals went out of its way to look at both sets of tests, the Kansas tests and the test used by other states, and said that even under the test of other states, what we look at, we're not just going to say that every and any law passed by a congressional body or legislative body was intended to create civil liability or under a theory of negligence per se. What they said is, look, if the statute, there's something in the statute or about the statute that gives us a reason to think that this was intended in that way, then we will so find. So, for example, the touchstone, as the Court of Appeals opinion in this case recognizes, was the statute intended to protect a specific group or class of people. So, for example, in our state, we have the Ringler case. And the Ringler case involves the neighbors of a feedlot saying, hey, there's this ordinance or statute that says that your livestock wastewater facility has to be so far away from the neighbors. Well, that was intended to protect the neighbors. And the neighbors rightfully have a civil cause of action, negligence per se or otherwise, as a result of that. That statute or that ordinance was clearly intended to protect a specific group of people. Now, is there anything about this federal firearms statute that was intended to protect a specific group of people? I stand before you here today where we've had a rash of gun violence in this country.
Well, that's a causation question, isn't it? Isn't that really a causation? And let me go back to what your answer to Justice Rosen with regard to the expectation that someone will enforce any enactment. I think what Justice Lukert was trying to ask you is, isn't there an expectation that the public will conform their behavior to comply with every enactment? And it's not a matter of enforcement, it's a matter of complying with those enactments, which then sets up the standard of conduct that's expected. You follow what I'm saying? You want to talk
What-
about enforcement of every enactment, but what we're talking about is there's an expectation of compliance, which then sets that as the standard of care.
I would certainly agree that there's an expectation that people will follow the law, and I certainly believe that my clients did in this case, and I believe will so prove on the negligent entrustment theory that's been.
But that's not what we're here for today.
But what I'm trying to express to your honors is that there's a reason why the law is what the law is, and why the law has developed the way it has in our state on the issue of negligence per se. We have historically, for decades now, approached this question this way, that not every statute that our legislature passes, or that Congress passed, or that some city council passes, whether it would be on abortion or guns or anything else, whatever kind of issue it may be, is intended to create or give rise to a cause of action for negligence per se, and thereby ease the burden of a plaintiff in a civil liability action. That's not our legislature's intent. That's not what they're thinking about, and it certainly in our state hasn't been, given historically the law. And you have recognized in the Bland v. Scott case, for example, you've said this. This court has said that the legislature's decision to regulate by statute in some particular arena does not mean that the legislature intended to create a new cause of action in civil liability in that arena. And you said in the Kansas State Bank versus Specialized Transportation Services case, where someone tried to bring a negligence per se action based on the mandatory child reporting statute, where someone failed to report negligently, allegedly, that legislative creation rather than judicial creation is a persuasive policy argument. That's what you said. Legislative creation rather than judicial creation is a persuasive policy argument. That has historically been the law in this state, and it should be no different here. And if there's anything that as I was about to say, this rash of gun violence around our country has demonstrated, is that this federal firearms statute that's to keep guns out of the hands of, in this particular case, a felon, albeit, of course, as your honors have pointed out, we don't concede or would not even suggest that it was an intent on our part at all to sell a gun to a felon. But this particular statute that was designed to protect from the sale of guns to felon is designed to protect all of us, whether we're in a school or we're going to a movie or in our place of worship.
So if there's a statutory
duty,
if there's a statutory duty that is created by the legislation that affects more people, there's less of an obligation to carry out that duty? That seems kind of...
That's not my suggestion at all, Your Honor. We have focused again...
Isn't that the effect, though, of what you're talking about? The broader that the legislation is, there's less of an obligation to carry out that duty?
The broader the protection intended.
Right.
That is what you're arguing.
I would look at it the other way.
Well, but isn't he correct? The broader the protection intended by the legislative body, the less protection it offers to any individual within that protection.
In terms of a negligence per se action, and that being less likely that there is a basis, not only in our state but in countless states across the country, that there would be that one of the basis on which a plaintiff could pursue a civil liability action for injuries in that case under negligence per se, there is less likelihood of that.
The answer is yes.
The answer is yes in that sense.
The answer is yes, and isn't that counterintuitive, which I think is where my colleague was headed.
And I say no, and I say it's not counterintuitive because, again, what we're looking at is policy, and historically what you have said is policy. You are the highest court of our land, of our state, and what you have looked at is what is the policy here. And you have said legislative creation rather than judicial creation is persuasive policy argument. What did the legislature intend here? Are we suddenly going to tell the folks across the street in the legislature that, well, in all these years you've been relying on our cases that we didn't say you had to say every time you pass a statute. Now, wait a second. By passing the statute, we did not intend to create a situation in which there's a civil liability action that could arise out of this in which the plaintiff's burden of proof has been eased because any technical violation of this statute that had some causal connection to someone getting injured suddenly gives rise to a negligence per se action.
Counsel, what specific language would satisfy you to be added to the statute so that negligence per se doctrine would apply? You said the category is much too large. How specific would the language limiting that have to be to fit our factual circumstance?
The language used by the legislature
Yes.
in a statute? Well, you have, first, I believe the touchstone is whether it's designed to protect a specific group of people or not. And we've already touched upon that clearly the statute was not. But secondly, whether there was some legislative intent is in part, I believe, derived from the first question. That is, was it designed to protect a specific group of people? If it was, then you can infer some measure of legislative intent right there.
I'm saying what language would satisfy you to specify the class of people that the legislature meant to protect?
Oh, now I understand. I apologize, Your Honor. I didn't understand. That's a difficult question to answer, Your Honor. Hypothetically, to go through every statute in our books and look and see what language would have to be added to that.
What about this particular one? What would satisfy you?
What would satisfy me that it was
intended to protect a specific class of people? What would satisfy you? What would satisfy you that negligence per se was applicable? I think that's
if there was, there would be two ways of a legislature or Congress in this case approaching that. One would be to say outright that there's the intent to allow civil litigants to pursue a negligence per se action based on a failure to comply with these standards.
Right.
That would be a clear expression of legislative intent. And then I suppose if there was a statement in Section 922D regarding sale to felons that it said that this is designed to protect a specific group of people, however that would be defined.
So the specific group of people in this case would be the son who was shot by a father who purchased the gun illegally. Does it have to be that narrow to define the class of people?
Well, let me approach it this way. We could look at what, for example, the Florida court did. I'm not suggesting agreement with it, but what the Florida court did in the Tamiami case, where they said that the portion of this statute that relates to minors and the sale of guns to minors is intended to protect minors. And I don't agree with that analysis, but nevertheless, that's one way you could infer from the statute that it's intended to protect a specific group of people. We don't want minors buying guns, and so we're going to protect those. The design of that statute is to protect the minors who do. I believe it's broader than that, and it's intended to protect everybody in that situation. Now here, by contrast, we have the statute, or that portion of the statute that regards felons. It's not designed to protect felons.
But why isn't it? If you were going to agree that the sale to a minor was intended to protect everyone, why doesn't that same analogy apply to the sale to a felon?
It does.
And
it does, but it's even more clear here. Pardon me?
And it's the everyone that impairs it, in your view. That's your argument. The fact that it's intended to protect everybody means it doesn't protect any one person or, as in your words, make their cause of action easier to prove.
Yes, and not to quibble, but it's not my view. It's yours. It's been yours historically for decades now.
And
that unless it's designed to protect a specific group of people as opposed to the public at large, negligence per se, civil liability does not arise from that statute. That has been your rule
why
for
can't
decades.
we infer that intent from a provision that would allow a negligent entrustment action? If there was language that allowed, that Congress specifically says we recognize the possibility of negligent entrustment actions, why does that not transfer? Would that transfer on to say we recognize a duty in other ways for a negligence per se?
Are you intending to make reference directly to the Protection of Lawful Commerce and Arms Act?
Yes.
Okay. I realize that there is this reference to negligence per se in that statute that Congress passed, and I also appreciate Justice Biles' position that that's circular reasoning to take that statute and say that that statute was designed to create a cause of action for negligent
I don't want to focus
entrustment.
on that statute
Okay.
necessarily. We're still trying to follow up on what is enough. And is that enough? And if that is in a statute about a sale to a gun, if there's a statement such as, we recognize a negligence entrustment, can that also be a negligence per se, an intent that it's establishing a duty that would be applied in negligence per se?
All right.
And then after you answer that, I would like for you to answer the question, or go where you were going with the follow-up to Justice Viles'
Okay.
point.
So if a statute was to specifically say that, if the legislature, let's say, in passing a statute said, and part of our purpose in this statute is to create a negligent entrustment action, and here would be the elements of negligent entrustment under this statute, would that also then give rise to a claim for negligence per se?
Would it be an indication that Congress is recognizing there's a duty and the potential for civil liability to enforce that duty?
I suppose hypothetically it might. I think that in that case, what the legislature is saying is the cause of action that we intend to arise by this statute we've just enacted is a cause of action for negligent entrustment. And
period, end of story.
Period, end of story. I would, and I'm struggling. I'm genuinely and authentically struggling with your hypothetical, Your Honor, to try and give you my genuine and authentic answer to that would be, I would think that the result would be that the statute was intended to create a cause of action for negligent entrustment, not negligence per se.
And it becomes more than a hypothetical because of that language in the statute that we're dealing with.
Okay, and that's why I thought that's where you were going, because as we know, the Protection of Lawful Commerce and Arms Act that Congress passed was designed to eliminate a lot of causes of action, some of which I gathered from the outset of this case the plaintiff might be trying to make. I was never quite sure. And only authorizes these two if the state law recognizes them, negligence per se and negligent entrustment, and it specifically defines what negligent entrustment claims may be made in a context like this based on the federal law. So, I mean, the standard is in the federal law here. And
that's the level of precision that you would say our law requires, Kansas law would require? The level of precision of stating a legislative intent?
I am not saying that. Let me be clear. Now, this statute, I think, is different because this is a statute of limitation. That's a bad way to put it. The statute is designed to limit what causes of action can and cannot be brought and to define that. If what I'm hearing you say, and so I would contrast that kind of statute from a statute that, as I understand from your hypotheticals, is designed to enable a specific cause of action. It says, here's the law, here's what you aren't supposed to do, and, oh, by the way, we're going to say that there's a cause of action for negligent entrustment under this particular statute. If you prove A, B, C, D, then you have that a private litigant may recover in civil liability. But I would contrast that kind of statute, which would be an enabling sort of statute or a creating statute, versus this statute, which is designed specifically to limit the kinds of causes of action in this context that may be brought.
One question. You continuously refer to the sea change that this would be if we were to, you say, decide that this is a negligence per se situation. I wonder how you address then our case law that seemed to be consistent with the appellant's argument today, like the Nolan case in particular or the Greenlee case, and it's those cases seem to indicate that there was there is negligence per se, and it's a much more basic concept in Kansas, and then somehow we moved away from that, like in the early 90s it appears. But was there ever a statement by this court rejecting or overruling the Nolan case, for instance?
Your Honor, I believe that's a very fair point. My analysis of those cases, though, across the board would be the standard was always the same. If you actually look at the standard used and enunciated in those cases, it was always the same. There were issues
Let's
of
talk about the
application.
Nolan case in particular. The appellants have focused on that. That's the building code requirement of having a handrail for steps. And basically, they said that, when you violate
And no-
that, it's negligence per se.
Right, and they do
What-
say that, and it's dicta. I mean, if you actually
Oh, it's
read
dicta,
the Nolan
okay.
case and you read what the issues were,
Okay.
that wasn't one of them.
Okay.
Now, I don't know if the defense lawyer dropped the ball and just didn't argue, hey, there is no negligence per se cause of action arising out of this statute, and just missed it. That happened apparently in Arredondo also, as we see. There's just this assumption that there is this negligence of per se action, cause of action, because apparently it had never been raised, and the only issue in the case was, do we get to do comparative fault?
What about the
negligence per
Greenlee
se
case?
cause.
Can you address that? That was 1987.
You're going to have to help me with that one.
I'm not sure about the facts either, but I think that they basically accepted the negligence. We basically accepted the negligence per se concept, but added to it that you have to make sure that the injury is of a character that the legislature was intending to prevent, which still is kind of along that lines.
I don't recall the Greenlee case being one in which the standard was any different.
Okay.
The-
Well, I guess
the
I'm just trying to
application of
get
the
to
standard-
is this really a sea change, and has this court ever really rejected the appellant's argument here?
Yeah, yes, most
Okay.
definitely. The standard across the board is the same. There have been some, I would say, odd, and I might even disagree with, applications of the standard along the way. In Schlobohm, or to the extent it was applied, although I disagree that it was, in Noland, and cases like that. There, let me pause just a second, since you did raise Noland. One thing in Noland that they made a note of is that the legislature itself specifically said that the purpose of the statute was not to deprive anybody of a civil liability action in that case. It wasn't at least intended to limit the ability of somebody to seek to file a civil action. So there was that. They did make note of that.
So
And that
your
is something
argument is
that might
it was
distinguish.
dicta,
But I believe it was
but there is
dicta,
this
though.
distinction.
Right. And Schlobohm recognized that distinction. And Schlobohm also said, gosh, we're stuck with the same kind of ordinance or statute here that we had in Noland, and we don't really want to be inconsistent with Noland, so we'll just kind of go with it. That's how I read Schlobohm. Now, that said, I don't think the standard has ever been there's any inconsistency in the standard. It has been the same across the board. And the touchstone of the standard, as the Court of Appeals in this case recognized, whether it's this, as some might characterize it, more narrow Kansas law or Kansas rule for negligence per se, or it's the test that's used more widely according to Professor Westerbeek and others. The touchstone of it is the statute designed to protect a specific group of people? And if it is, well, we can infer from that there was some legislative intent that specific group of people, a person who's a member of that specific class or group of people who gets injured, could bring a civil cause of action based on negligence per se. And that seems logical and reasonable and rational, and that has been the standard of this court for years.
Let me ask you about that, because there's a reference in the plaintiff's brief about the fact that the shooter in this case was under a protection from abuse order. Is there anything in the federal statute that requires checking for domestic abusers or people that are under domestic orders for protection of any kind? I don't know how it would be worded in the federal system, but it'd basically be folks that are subject to protection from abuse orders in our state.
I believe there is, but I'll be honest with you, Your Honor. I didn't come prepared to argue that particular issue today,
My
given the
point
Court of
would be,
Appeals
if
treatment
there
of it.
is something in the federal law that precludes selling firearms to people that are subject to protection from abuse orders, that would get us a lot closer to a class of people that are close to the victims in this case, wouldn't they?
I believe that's a fair point, Your Honor, that if the evidence had been presented in this case, and there was evidence that, or if when Ms. Shirley went to the police officers and asked for their protection, or went to her own lawyer and asked for protection, they had done something, and there had been that kind of order, and that was part of the record in this case, which the Court of Appeals has found it isn't, and that's not part of what's appealed or on our petition for review today. That might make a difference and that this person might be of a specific group of people that the statute was designed to protect. I see your point, Your Honor.
Do we have any further questions? Thank you, counsel.
Thank you, Your Honors.
Counsel, you reserve 6 minutes for rebuttal.
Thank you. First, let me quickly address some of the negligence per se points, and then I want to address our negligence argument. First of all, Justice Viles, there is federal law which prohibits people who are under protection of abuse orders from buying guns. That was claimed in this case. There, in fact, was such an order in this case. And, in fact, we made the argument that since Graham was prohibited under that as well, exactly your argument, Your Honor, that's a special class, and Zeus Graham was in that special class. So even under the more narrow test, we would have a negligence per se claim. The Court of Appeals rejected it because the court held that the only evidence of that order was Elizabeth Shirley's deposition testimony. There was not a physical entry into evidence of the order. We believe that's incorrect, and we maintain that argument. But so one, we maintain that as an argument for negligence per se liability. It also, however, exposes one of the problems. Why should that make the difference? Why should there be negligence per se claim if there was a protection order and Zeus Graham was killed, but no claim if he only was a felon? Or put another way, what if instead of killing Zeus Graham, he killed Zeus Smith, who was not his son? Then that would not be in the special class. You would not have negligence per se claim there, even if the order was in the record. What is the rational reason to draw these distinctions? We would argue that there isn't one.
What about the argument that these statutes are really, these federal statutes, since that's where we're focusing, are really simply federal disability or civil disability statutes against the convicted felon? In other words, it's simply to deny a right to them as opposed to a protection. Doesn't that intent, if there is that intent, legislative intent, have to enter into whether there'd be negligence per se?
Well, I think not, and because I want to address a broader point which I think relates to that, which is that we are not claiming that negligence per se creates actions. We don't need the federal law to create an action. There is a valid negligence action in this case, regardless of whether there's federal law or not. What negligence per se properly does is it simply uses the minimal criminal or regulatory standard as the standard of care in a negligence case. So the jury is no longer left to determining on its own what is the standard of reasonable care. Basically, it says if you violate the law, that's the rock bottom minimum. You can't be reasonable if you violated the law. So it does not create actions. It also doesn't ease the burden. In fact, it's a lesser burden. The minimal burden of a defendant is to obey criminal or regulatory law. The standard of reasonable care is higher than that. It's simply what negligence per se simply does is it says we're not going to allow juries to effectively nullify the law in cases where there's a violation of law. We're not going to allow them to say, I think it was reasonable to violate the law. And that's, in fact, essentially the argument here. So if I could, unless there are other questions on that, I'd like to
I have one very fast question that's a fact question. The PFA order itself is not in the record.
Yes.
There's testimony in the record from the mother of the victim about what that order covered?
Yes, she testifies that she...
According to that testimony, did the order cover her and the child, or only her?
My recollection is she speaks generally about it being a protection from abuse order and not going into the specifics.
Thank you.
Going to negligence, the Court of Appeals, in denying the negligence claim, misconstrued the basic negligence theory that we were propounding. The court viewed our theory as a duty to control Russell Graham, And then they cited cases saying you don't have a duty to control another person unless you have a special relationship with that person. That case law is exactly right, but it has nothing to do with this case. This case is a dangerous instrumentality case. It's about whether the Georges exercised reasonable care and control regarding a firearm. So that's the rule in Long, in Wood, in Roth, and many other cases. And as the law review cited in the Court of Appeals stated in referring to, it was either Long or Wood, and I'm quoting, breach of duty in one of those cases was defendant's failure to secure the gun, not his failure to control his child. What the authority is saying there is that if you possess or control or own a dangerous instrumentality, including a firearm, you have to use reasonable care with it. And it's our contention that that standard of reasonable care applies to gun dealers, not simply for negligent entrustment actions, but more generally. For example, if a gun dealer were to leave a gun out on the counter and when there are people there and then turn their back and someone takes it, there's an argument that that's not reasonable care. It may not be entrustment, negligent entrustment, but it's not argument that it's negligent. If a gun dealer sells a gun to someone illegally without a background check, where there are no red flags, the person did not say, like in this case, that I'm a felon, well, that they're violating their legal duty. It's our view that you also be violating the standard of care. That's not a reasonable gun dealer would have done a background check. So you'd have a negligence claim. There'd be an argument that you would not have a negligent entrustment claim because in that case there were no red flags that this particular person was dangerous. So there are a number of cases where you'd have a negligence theory but not a negligent entrustment theory, and there is no reason why a gun dealer should have a lesser duty regarding his firearms than a gun owner. I mean, in fact, under Long and Wood, the Georges could be liable for a shooting if Russell Graham was their son and they locked up their gun and Russell broke into their house and broke into the safe and used that gun to shoot Zeus. There'd be liability under Long and Wood. However, if they knowingly supply Russell with the gun and make money off it, it may not be a lot of money, may be a lot of money, who knows? But if they do that, under the Court of Appeals theory, there is no negligence liability.
What about the Court of Appeals' concern about the application of this negligence per se? The example that the appellee gave about writing down the license number wrong, leading to a negligence per se action, would cause gun dealers and people in that business just to hang it up and say, no, I'm not going to risk this anymore. What about that concern? Because they talked a lot about that.
I'm glad you brought that up, Justice Rosen, because I wanted to address that. And I think that's completely, the Court of Appeals position is completely incorrect. I mean, the fact is, if you had negligence actions in a case like this, the standard of care would be the standard of a reasonable gun dealer. That is not strict liability. It is not an overwhelming burden. It would be determined case by case. And in this case, it would simply be a reasonable gun dealer should have followed the law, which is that when you had reason to know that Russell Graham was buying the gun, you would do a background check on Russell Graham. But it would not be, all those parade of horribles that the Court of Appeals raised simply would not be viable actions, in my view, if you just applied the standard of reasonable care. And, you know, the Court of Appeals seemed to be sort of scared away by the language of highest degree of care that this court's used in other gun cases. But all that means is really, you just apply the standard of reasonable care, but the standard heightens if there's a greater risk in what you're doing. You just have a higher degree of care when you're selling a gun than if you're selling a ham sandwich.
When you say they might not be viable causes of action, you're talking about after a trial to a fact finder, however. They wouldn't be subject to summary judgment the way that they are now. Or potentially are now, which is one of the battles your opponent is fighting, I'm sure. That they don't want to have to go through a trial to figure out whether it's a viable cause of action.
I don't believe those cases would necessarily survive summary judgment. I mean, you'd have to prove that the gun dealer did not act as a reasonable gun dealer would do. That's all. And if you prove that a reasonable gun dealer would not have gone out in the parking lot and checked license plates, then you would win on summary judgment. So it's not I mean, this is the standard of care that applies to every other business. Every other business is governed by negligence. Why should gun dealers not be governed by negligence? And courts deal with that simply with a battle of the experts, usually, over what is reasonable care. But it's certainly not an insurmountable burden. And briefly on the point, Your Honor, about the failing to fill in the paperwork, the appellee's counsel was talking about the Pemberton case. Pemberton case, there was no violation of law. There was no case there. I mean, there's a lot of law that's really essentially dicta, because there was no violation of law, and there was also no proximate cause. I mean, if there was a paperwork violation, it had absolutely nothing to do with what happened in that case. So that's really not valid authority to rely on much.
Counsel, I just have one more question. I talked about Nolan, and you spent a lot of time suggesting that Nolan was really essentially where we had originally gone with this, and that we've never really gotten away from that, is the way I understood your argument. But I think in Schlobaum, we specifically said that we have limited the rule espoused in Nolan. Violation of a statute or ordinance alone does not establish negligence per se. And then we went on to kind of explain where we are on that, which seems to be where we still are. And so to me, I think it is a bit of a sea change it is a sea change you're asking us to make here, because we have rejected very specifically where we were before.
Except, Your Honor, that in Bland v. Scott, after Schlobaum, you have language that sounds a lot like the old rule, and it basically says that you have negligence per se unless there's an intent in the legislature not to have a cause of action, and as I said, there was that for dram shop liability. So it hasn't been consistent. I do agree, Your Honor, that most of the cases since then have been more narrowly focused, but as long as one recognizes the negligence per se is not a rights-creating theory, then there is no great harm in this sea change. All you're simply saying is that a civil jury can't effectively nullify the statutory or regulatory standard in a negligence action. That doesn't create a new cause of action, and it doesn't raise the bar of responsibility for defendants. It anchors it to at least the rock bottom level set by the legislature.
We have any further questions of counsel? I see none. Thank you, counsel.
Thank you, Your Honor.
Thank you both for your arguments this morning. The court will take this matter under advisement.